The Honourable David Parker.
Thank you, Mr Speaker. The Labor Party is supporting this legislation because we agree it's sensible that where people are serving community-based sentences, be they on bail or parole, that the authorities can monitor conditions that are imposed upon them relating to drug and alcohol use. That said, sir, I have to take issue with something that the prior speaker just said. He said that the government has an objective of reducing reoffending rates. Well, I want to highlight what's happening in respect of at the moment, contentious issue around serious sexual crimes. Do you know how they're cutting reoffending rates? They're actually not prosecuting and convicting them in the first place. You know, and you might think that that's a throwaway remark. It's actually grounded in fact. We have increasing numbers of serious sexual crimes being committed. We know that from the statistics. We also know that we have fewer convictions for those crimes in total. So despite a higher number of total offences, there are fewer convictions, and the clearance rate of those crimes is lower, as well as the conviction rate. So more crime in this area, fewer convictions and fewer clearances. Mr Speaker, that is not the record of a government that it should be proud of. Mr Speaker, I want to turn to another issue. We agree on, I think, all sides of the House here. I think there's very wide agreement that this is a good piece of legislation giving the authorities further powers to monitor people, including those on parole. People who serve a sentence for the most serious of crimes, murder, are sentenced to life imprisonment. They are generally then released after a period, depending on sentence, but it's generally around 14 years. And then forever, whenever they are released on parole, are released from prison, they are on parole for life, because they are sentenced to life imprisonment, but they are, after a period, released on parole. So those people, the most serious of criminals, are on parole for the rest of their lives. And the parole conditions can include monitoring for alcohol and drug abuse so as to minimise the risk to society that they'll reoffend. Now, just yesterday in this House, we were having a discussion as to why it would be prudent to send the legislation relating to returning prisoners from Australia to Select Committee. And the Labor Party had suggested a way in which we could guard against problems in that bill that hadn't been thought of in the truncated process as that was whacked through under urgency. We had suggested that the bill, which because of negligence by the government had not been introduced until yesterday, had to pass through all stages before those flights land with large numbers of serious criminals coming from Australia. And we knew that it had to be an under urgency, but we also knew that doing it under urgency meant that some of the flaws in that legislation would not be picked up. And so we said that that bill should be passed through all stages in one version with a termination date of a year, and a second version of that bill go to Select Committee immediately to take effect on the expiration of that in a year and to sort out the problems in the meantime. This is an example of a serious problem. Because, you know, we've heard from the government how important this bill is so that we can monitor people on parole. Well, what happens to those people who are coming back from Australia with murder convictions? Does this bill apply to them? Can I have an answer from the government? No, I can't, because the answer is no, it does not. And that problem could have been fixed in the next few months by that parallel process that I have been talking about, fixing this aspect of the legislation that applies to returning offenders from Australia. At Select Committee, any one of us could have listened to this debate. This thought hadn't occurred to me until I actually prepared for this debate today. I didn't think of this yesterday when we were considering the returning offenders legislation, but we could have, or we would have had submissions from the Law Society or from the rape crisis or from people who represent the interests of victims of crime, or from the rehabilitation people like PARS or the Howard League for People Reform, someone would have picked it up, even if no MP did, and they would have said, you need to make sure that in respect of these people who would have had parole conditions in Australia and are now returning in New Zealand unsupervised, that the ability of the New Zealand authorities to appropriately supervise them and protect the New Zealand public by having similar to parole conditions imposed in New Zealand, including in respect of drug and alcohol abuse and the monitoring thereof, they would have picked up that it's absolutely obvious that this legislation should be applying to those people too. Now, I think this is yet another illustration of the, I've got to say it, the belligerent, myopic stubbornness of Amy Adams on this occasion, because what I was proposing through the Labour Party would have not only got the balance right in respect of protecting the civil liberties of New Zealanders and making sure that we're not going too far in the legislation. As I said in those debates, it would have also ensured that we were properly protecting the New Zealand public. As a consequence, the day before the government stands up and heralds this legislation as better protecting the New Zealand public, we haven't picked it up. We haven't picked it up. We haven't heard from the government that we have got this gap now in the New Zealand legislation, which means that the drug and alcohol testing of community-based offenders and Bailees legislation bill, which applies to, amongst others, people who are on parole, will not be applying to the people who are coming back from Australia. Now, having alerted the government to the issue, I hope that the government or their officials actually listen to this debate and have the good grace to come down here in the committee stage and actually amend this legislation before it goes through to make sure that it applies to those returning offenders. But it does show how important it is to New Zealanders that you have a decent opposition who are actually pointing out the negligence of this government when it comes to protecting the interests of New Zealanders. I am shocked that our offer from the Labour Party, because we offered to support that legislation through all stages under urgency. We offered to support them at the Business Committee to make sure that a parallel copy of the bill could go through on the same first reading so that we were debating two versions at the same. We could have done that by leave of the House. All parties, I think, would have cooperated with that.
Thursday now.
What's that? Thursday now. It is Thursday. That's right. And what's your point? Is that your only contribution? He's waiting his turn. Right. Well, it would be good if the members of the National Party did stand up and take a call to explain why it was, Mr. Speaker, that just yesterday they refused to have a parallel copy of the bill that was, the act that was now an act that was passed in respect of returning offenders from Australia and elsewhere going to select committees, so that these very sorts of problems could be sorted out. Mr. Speaker, I probably said enough in respect of that issue. I will return to the original theme of this legislation, which is that it is obviously desirable. Well, it would be novel. That's the member said.
I'm going to ask the member to resume his seat. I am going to suggest to members on my right that the member is making a serious contribution on very serious legislation that affects the lives and the safety of New Zealanders, and I think flippant interjections like those made by two members are inappropriate in this circumstance.
The Honourable David Parker.
Thank you, Mr. Speaker. We all know in this House that drug and alcohol abuse is associated with criminal offending. When people are under the influence of drug and alcohol, their inhibitions reduce and they are more likely to do silly things that they might themselves later regret, but which certainly their victims are adversely affected by, and that accordingly it is good if we can, as we move towards community-based sentences, and I would acknowledge the Honourable Bill English in terms of some of the moral leadership that he's shown in the National Party in terms of recognising the ineffectiveness of some prison-based sentences and how it is more desirable that you have both programs within prisons and after prisons to minimise recidivism. And I think the Honourable Bill English deserves some credit for that, and I give it to him. And if you're going to move to those treatment programs and things, part of the way in which you make them work is through the sorts of monitoring that is proposed by this bill, and that's why the Labor Party will be supporting it.
Todd Barclay.
Thank you, Mr. Speaker. I rise to speak